But in the interest of time, I'm going to go ahead and get this started. It is being recorded, so we're going to also we post it on our Academy online, as well as share the recording with folks. Um, but a couple of things before we get started. First of all, I'm John Blake with Anytime AI. I'm the VP of Revenue here, and thrilled to have Michael Donahue from Stark Stark join us. Before we get to his introduction, this is a CLE webinar, which means that you will get 1 hour of CLE credit as long as you do stay for the entire time. And on the bottom of your screen, you'll see a little question mark that says Q&A. If you have any questions during the presentation, go ahead and ask them there, and we will try to get to all of the questions that we can. And if not, we'll try to follow up afterwards on any questions that we can't get to during the presentation. And with that, I'm going to go ahead and do a brief introduction of Michael. So, because a longer introduction will take far too long, there's a lot to Michael. But Michael is the managing partner at Stark Stark. He's a certified civil trial attorney. He does specialize in product liability litigation, and he often lectures on tort liability as well as trial settlement. He is on the board of governors at AAJ, and currently and past has held a number of different seats on various committees throughout AAJ, NJAJ, and the New Jersey Bar. He was also the past chair of the civil trial bar section of the New Jersey State Bar. And so that is a very brief, abbreviated version of an introduction for Michael, but we're thrilled to have you here today. I appreciate your time, and I'm going to go ahead and turn the platform over to you.
Thank you very much, John. It's very kind of you to ask for me to participate in this, and thank you for that very kind introduction. Ladies and gentlemen, I think the most important thing in my background that I could share with you is I've learned from a lot of failure over the years. I've learned from failure in cases. I've learned it from failure in management. I've learned from failure in life. And I think, as all of us who are trial lawyers know, you learn a lot more from failure than you ever truly derive from success. You never knew what led you to win something, but you always knew what cost you the loss. And one of the things that I want to talk about today is how we can avoid failure by taking some preventative, some protective, and some positive steps in the use of a tool that we're all coming to believe is the true future of our legal practice, and that's the incorporation of generative artificial intelligence and what we do on a day-to-day basis. And I want to thank Anytime AI for the opportunity to talk about this today with all of you in terms of use and implementation policies. Why don't we bring up our opening slide? And I also want to, make it clear that, this is really a tremendous product. This is every day here at Stark Stark. We're learning from the product. We're learning how to better use the product, and ultimately we're becoming more efficient and more effective with Anytime. And it all comes down to how much effort you want to put into the planning, the change management that's associated with implementing new tools, regardless of where they come from, and then ultimately the willingness of your folks to really dive in and learn. Change is always hard. Change is difficult. Change is different, but change is through the difficulty that we encounter going through change. That's the only way we break through to progress. So let's talk a little bit about how perhaps we can make these transitions, these changes, a little easier for our folks, and more and safer and more ethically compliant for all of us. So a little bit of background about artificial intelligence. If you're here, you probably know this, but it feels like my duty to start with this because this is, it seems like very new technology. It has been around for some time, living under the covers of many of the things that we do. I mean, artificial intelligence refers to technology that enables machines to mimic human intelligence, a very broad, a very large umbrella. And then when we dive down, when we look at machine learning, machine learning is, it's a subset of artificial intelligence. Machine learning is the algorithms that detect patterns, that allow machines, computers, to learn and to adapt. We have all been experiencing some aspects of machine learning and many of the things that we've participated in the last, quite frankly, the last couple of decades. Um, then there's deep learning. That's a much more refined, a much more intensive subset of machine learning that involves using neural networks for in-depth data processing and analytical tasks. And then even beyond that, a smaller subset of deep learning is generative AI. And that's really the focus of tools like Anytime AI and other tools that are generating new information, generating images, generating summaries, generating data from existing sets of data. This is where we're really seeing neural networks um, go to the next level of generating content, not just taking and combining content. And with anything that's new, we have to fold that into the framework of the old. And for us, the framework that we must always start with is really our ethics. Uh, Nationally, many of us look to the ABA RPCs and the formal opinions for some general guidance. All of us work in different jurisdictions. Your rules of professional responsibility or your rules of professional conduct differ slightly, sometimes differ greatly from the ABA formal rules. But one way place to start is the ABA Formal Ethic Opinion 512, which talks about generative artificial intelligence and how those tools interact with the RPCs. And there really are 6 areas that the ABA, in its opinion, mapped out to consider when you are using artificial intelligence tools. First, are you meeting the duty of competence? Quite frankly, that question is whether are you using tools that are closer to the computer than the abacus? Are you using the technology that modern day society has recognized as reasonable and useful rather than being stuck in the past and using outdated and perhaps ineffective tools? Um, are you maintaining the duty of confidentiality? Uh, Really, the cornerstone to ethics for all lawyers is whether they're keeping their clients' confidences private, and that the protection of the attorney-client privilege gives us an advantage, quite frankly, a competitive advantage over many others who could do some things similarly to us. And protecting a client's confidence is our utmost duty. Are we communicating in an appropriate way? Are we letting the folks know who need to know and have the right to know that we're using various tools? Today, we're talking about artificial intelligence, but are we letting our clients understand how we're meeting the tasks or fulfilling the tasks that they've engaged us to do? Are we being truthful and just as importantly, accurate to the tribunal? Are we making representations in court? Are we making representations in papers to the court that are accurate and truthful? And are we doing everything that we are required to do to maintain that candor, that accuracy, and that truthfulness? Are we engaging in the supervisory responsibilities that we have? There are very few lawyers out there who are truly one-person shops. Um, Even the smallest of firms generally has a staff person or a paralegal, or a blending of those two functions in the practice. A person who's not licensed to practice law but is performing tasks under the supervision of a or many licensed lawyers. That supervisory responsibility has always existed. And now we're looking at that responsibility in terms of a different tool, a non-human tool. How are we supervising the activities of that tool and performing functions? And then the effect on fees. I suspect to most of the folks that I'm speaking to today, or most of the folks who take a look at this, the fees aspect of the ethical analysis is probably not a very important part of it. If you were doing contingent work, um, you are not struggling with the issue of whether and how you bill the completion of the task that once took a lawyer an hour to do, but now takes an AI tool seconds
Minutes.
or minutes to do.
Yeah.
Those are not issues for us to deal with. Those are issues for our, our many times our adversaries, other types of lawyers, but it's not something that contingent lawyers struggle with. And quite frankly, it's one of the great advantages of why we need to be looking at these tools, because these tools have the capacity to make us more efficient, more effective in their advocacy, and ultimately deliver our service in a manner that's much better for our clients because they're getting the resolution quicker and perhaps getting a better resolution.
Michael, I have a question
Sure.
for you. So I was at a conference the other day and spoke to an attorney who, well-respected attorney, he's been around for a long time. And he said, I'm not going to let my firm use AI because I think it's going to make them lazy. And I don't want my firm to be lazy. How would you respond to an attorney that said that? And this is not a stupid attorney. This is
Sure.
a very well-respected, very well-to-do attorney.
So if you think about each level of technological advantage that our profession has enjoyed, I think at each one of these paradigm shifting moments, um, you've looked at tasks that once a staff person or a junior attorney were asked to do that were more manual and intensive in labor, but less thoughtful. They were spending the efforts and their time on actually producing something. Go back to the typewriter. You know, typing is hard work, requires a tremendous amount of concentration. You make an error. Way back in the old days, you're using whiteout, you're using,
Correction tape, whatever. Yeah.
correction tape and those things to fix. It's a very time intensive task. The word processor replaces that. These people didn't become lazy because they didn't have to use correction tape. Now that time can be devoted to a more thoughtful activity. It frees them up to do higher level work. I don't personally believe that AI is going to leave land along the legal landscape, littered bodies of staff members who've been replaced, but rather we're going to be hiring staff that are perhaps have a greater capacity for judgment, have a greater desire and ability to engage in thoughtful work. We're taking away the information gathering, which AI can be wonderfully useful at doing, and freeing up those individuals to work on analysis and advocacy and the actual presentation rather than the collection. It's not going to make people lazy. It's just going to shift the type of work and where they're really putting their focus, and getting you and giving you the opportunity to get, quite frankly, a more efficient staff person, and to get a person that's working at a higher level that's generating better work for you.
I agree. That's a great answer.
So I'm going to turn quickly to the New Jersey guidance. I'm showing you, I'm in New Jersey. I think about New Jersey. I don't show this because New Jersey is special, but every state has their own, or will have their own guidance about artificial intelligence. And I think New Jersey's guidance is particularly useful because, importantly, New Jersey spoke, when they first started talking about artificial intelligence, they made the point that AI doesn't change the lawyer's duties. And in fact, the analysis of anything having to do with AI comes by using these old ethical rules, and the same ethical rules that we've always used. And you see a very similar recitation of the important factors: accuracy and truthfulness, honesty, candor, and communication, confidentiality. Prevention of misconduct was something that New Jersey looked at very closely. I think New Jersey had the benefit of coming a little later and seeing some of the problems that have emerged, and then the oversight issues, supervisory issues. So now it comes to, how do we comply with these ethical duties? We know that they exist out there. We have this new tool. How do we use this tool? How do we manage this tool? How do we manage generative artificial intelligence? How do we manage anytime AI, so that we're complying with our ethical duties, and we're giving our people the guidance they need to use it responsibly on a day-to-day basis? The vehicle to do that is an AI use policy. Now, I don't expect that the vast majority of the people who are listening to this get overly excited about policies and procedures. There aren't that many people that get overly excited about policies and procedures. Maybe if you're joining a webinar on a Friday afternoon, you're a little different than the average bear, and you're a little bit more interested in policies and procedures. But generally speaking, policies and procedures are things that we have to put together, that people have to follow. It's a lot of have tos instead of want tos. I would suggest that this area and this issue is something that, open up your mind a little bit and think about this, because we are at a point in the adoption of this technology that we are getting beyond the fascination with the novelty of the magic behind generative AI, and we're getting to the place where it is actually moving the needle. It is making a difference with the things that we do. And when we move from novelty uh, to actual work, one, we have to be very careful, but we have to recognize that our people who have been working under a different paradigm with different tools need help to move through this change process. Now, why should you develop an AI use policy? There's really two reasons. One, you want to create a framework that supports the responsible use of AI, and specifically understanding the practical and ethical uses, the issues with respect to accuracy, the issues with respect to completeness, the issues, importantly, with respect to privacy and security. But you also want to give your people real support and how they're using them, and what's the appropriate use, what's the inappropriate use, and the background as to why these particular tools have been chosen, and the framework that's used in choosing them. A little bit, I'll talk for a moment or two a little bit about what makes a policy good. Um, we don't make policies just for the sake of making policies. And when you have too many policies, you essentially have no policy, because people can't work through them. But ultimately, a good policy is something that helps people deal with the various duties and responsibilities on a day-to-day basis, while at the same time meeting the professional norms, making sure they're performing their work with integrity, and meeting the highest standards of ethics. You're trying to provide good guidance on a daily basis, You're trying to identify all the necessary ethical and legal norms. You want to create an environment where folks feel psychologically safe to respond and ask questions, but also they're going to be responsible to follow the policy and therefore use the tools that are being given to them to use. Ultimately, we all need to create a place where the clients feel that the trust that they give us is reciprocated and they have a lot of confidence in us. And ultimately, we want to avoid problems, intentional problems like misconduct, but also negligent problems. People not understanding the limitations of tools as well as not understanding how the work product can be misused. What is an AI use policy? And quite frankly, these backbones of inclusion are the backbones of most policies. We need a purpose and we need a scope. We'll talk a little bit about each of those. What are the general principles that underpin the policy? What is the framework that folks are given for the use of a particular tool? Particular guidelines about use cases, what's appropriate use, what's possible appropriate use, and what's forbidden use. How tools are approved, how tools are implemented, the importance of training, retraining, and then how issues that arise are either reported or dealt with. I've talked about this a few times in various settings, and whenever I get to this particular part of the presentation, I always question, why are we telling people why they need to incorporate a purpose? Let me answer my own question. Because when a new policy is presented to anyone, regardless of whether we're talking in the AI world or any other policy, it could be a dress code policy, it could be a conduct policy. Without writing down what the purpose of the policy is, you will have confusion. You, in and of yourself, you're cursed with knowledge. You know what you're creating this for. But the new employee, or even the employee who has been with a firm for a number of years, when faced with this, needs to clearly be placed in the same position that you are in terms of how it's being proposed. And providing a purpose statement is a very important part for getting people focused on what this is about. I also think it's important to note at this point in time that these policies are important for a firm of any size. If there's more than you need to write it down. There will be, in all likelihood, more people besides you, even if there's only one other person now. If there's only one other person working with you, that person may need to leave or have to leave or whatever and be replaced. Once you write it down, you're creating something that everyone currently working with a particular tool can look at, but you're also creating consistency for the future. And writing it down, even in the smallest of firms, is very important. I also think it's very important in a smaller firm that everybody have an opportunity not just to be presented with policies and presented, for instance, with the purpose of policies, but to have some opportunity to talk about it, to discuss it, and to really feel like any questions that they have are answered, and whether they have additional input, it can be addressed. The larger the firm is, the more sophisticated the change management processes are. There's meetings, there's presentations and things like that. When we're in smaller firms, we sometimes those aren't important, but it's really important to put new policies in front of your people in a place where they can ask questions and respond. Scope. Any policy, and an AI policy in particular needs to address scope, who's covered. Obviously, it's anyone working directly for the firm, but it also could involve people who are working at more of an arm's length level, like a contractor. Um, Importantly, the term consultants is used here. When I see consultants, for us who litigate on a frequent basis, really talking about expert witnesses. These policies need to be provided to people that are either going to have access and use to the tools, the AI tools that you use, but also if they're going to use AI tools, if you don't have a separate policy that addresses your vendor's use of AI tools or your vendor's use of various products in general, you may want to incorporate some aspect of that here with respect to AI, because it is very important to understand ultimately where your data is going. And if others are using AI, you need to understand how they're using it and to assure that they're meeting the proper privacy and security stances that you employ, but also and most importantly, you need to understand how they're using it to complete substantive tasks. What are the general principles? I'd suggest to you that the general principles of any AI use policy need to cover three general areas. They need to address data security and privacy, your client's secrets, your client's documents, your client's medical records, your client's fill in the blank. We take great pains to make sure that they aren't shared without the client's consent. And we need to make sure that the tools that we're using, particularly in the generative AI space, are up to that level of security and are respecting the privacy that we need them to respect. Also, accuracy is incredibly important, and understanding the limitations of accuracy is vital to using any type of legal tool, but in particular, a generative AI tool. Look, none of us are perfectly accurate. I get things wrong, right? Everybody at this program, watching this program, they get things wrong sometimes. Our best staff, the best staff member, the best staff people you've ever had have gotten things wrong at times. The best associates, the best young partners get things wrong sometimes. People get things wrong, machines get things wrong. We have to understand that accuracy is never assured. It always has to be tested, reviewed, and verified. And then completeness. We layering in a generative AI tool in the arsenal of other tools that you're using can be an incredibly powerful thing, but it is a tool in the arsenal that you have, and without understanding the complete area of the law that you're dealing with and where this plugs in terms of the tasks that's being asked to perform, you have to understand the limits of the product or the tool. And here's an example of a general principles that lay out these three concepts that I was just talking about. I'm not going to read this to you. It's in the materials that you were shared. But through taking a look at this, you can get a flavor for what we're trying to accomplish in terms of balancing brevity together with clarity and completeness.
So we have a couple of questions that came in. Do you mind if I jump in with a
Absolutely. This is a perfect time.
All right. So the first question that was asked is, what is your feedback on the fact that there are AIs that also now do the higher level work? I know my answer to that, but I want to hear what yours is.
Well, if you've been sitting through any AI presentations, you've heard that, that term trust and verify is very, very important. And maybe we need to put a big X through the trust part and just focus on verifying. So I'm agnostic, quite frankly, on the higher level work in the sense that, of course, it's going to do higher level work. The generative AI tools are going to get better and better and better. They're going to become more and more effective, more and more efficient, more and more accurate. But there will always be a certain degree of limitations. They're limited by the information that they're working from, and then their capacity to analyze based upon the information that they're working from. So, to the extent that incomplete or a limited set of information is provided, you will almost invariably get a limited or incomplete response. I personally believe that we're moving towards the place relatively soon where generative AI will offer true legal judgment. Now, it remains to be seen whether that true legal judgment is something that someone um, can reasonably rely upon. But for at least the foreseeable time being, I think we should all make sure that we're exercising independent legal judgment to analyze, review, and ultimately verify the results of anything that comes out of AI. Um, AI could be functioning at a level that's the equivalent of a lawyer with 45 years of experience who's tried, a couple hundred jury trials and been exposed to everything. We all know those people. They're invaluable resources. Um, you sit and you talk to them, you get perspective, but they're not always right. And this tool is going to be the same way. We're not talking about actual uses of AI, but I think one of the most exciting personal uses that I've experienced is the ability to quickly get feedback and engage in a process of thought about something when I don't have somebody else immediately available to talk about. When the guy or lady sitting next to me on the airplane doesn't want to talk to me about how I present a weird issue in a products case, I can go to the AI. And it'd probably be better than my seatmate on the airplane.
Yeah, and from my perspective, AI is getting smart so incredibly quick. It can do, you put in a bunch of medical literature, you put in your documents from your case and say, where did they not follow the standard of care? And it'll give you a report with citations to the actual document. You still, as an attorney, still have to go through those and see how it applies to your case and how you're going to use it within your case and use your own reasoning behind that. It is, the whole trust but verify. I'm right with Michael on, you know, uh, more verify than just trust. It is a tool, right? So the when you went from a handsaw to a chainsaw, it made the person that's cutting down trees more efficient. It still didn't say, the chainsaw didn't tell you the best way to, clear a whole area of land. It just gave you a tool to do it quicker and more efficiently. It's very similar to how I look at AI right now, is it's going to make you more efficient and let you spend more time on the more critical thinking tasks and get rid of some of the grunt work. But it's in no way going to take, I don't want any attorney to think it's going to spit out a product that they don't look at and just hand in. And if you're doing that, quite frankly, it's malpractice. So that'd be my answer on it. There's another question that is here that says, I see that clients are starting to use AI as a means to circumvent their attorney, whether it's for transactional or for litigation. If, for example, when AI recommends certain defenses or causes of action to the client, and it's a schizophrenic answer from AI, which it can be, what would be the ethical policy if the attorney gets into a dispute with the client where the client is adamant about asserting a cause of action that AI recommended, and to the attorney, it's bad faith cause of action to assert.
Yeah. I mean, I think that's a real issue with these tools in the sense that um, lay people who are conversant with this technology are obviously using it on a very regular basis, either to evaluate the work that we're doing or to substitute the work that we're doing. Um, the the issue, though, isn't really a new issue. All of us over the years have had clients who've had a family member or a very close friend who was a lawyer who didn't do the type of litigation that we're involved in, but has a lot of ideas about the litigation and how it should go. And sometimes that comes through the client to you. You know, why aren't we doing this? Well, why? And your first thought is, why would we do this? But you know, it's you got to meet the client where the client is. So, you know, if the client is coming to you with things that are um, either obviously, you know, not applicable or quite frankly, they're on the bad faith level, you have to sit down and explain to the client, you know, why that what that is, you know, what that's for, and why it isn't appropriate here. But I don't think it's a new problem. It's just a new vessel that it comes through. The issue about whether it's going to substitute for work is a very real issue. And you know, our firm is we're about 100 lawyers. We have a very large personal injury practice, about 40% of the firm. But we also do transactional work and some compliance work in a few industries, as well as some other consumer-facing work. And the variability of information that clients come to us in the for non-PI practices, um, correct or incorrect, um, it sets the tone for the client relationship. And sometimes in those areas, you're spending as much time explaining to a client why the good ideas they received from someone else or a computer are not, in our view, you know, the way that the case should be handled, or the way the transaction needs to be pursued, or the format or the structure that the entity needs to be put in. And, you know, at the end of the day, they're coming to us for judgment, and you have to explain to the client um, why you feel a particular way about the judgment about the judgment issue that you're providing.
Yeah, and I think it's happening in a lot of fields right now. So especially the medical field where people are asking AI, these are my symptoms. What should I be taking? And then they go to the doctor and the doctor does a physical exam and looks at the tests and says, this is what I recommend. And they go, well, no, the AI said I have this problem. And I think that a whole bunch of professions are dealing with the same thing. And it's, you went to the doctor so you can get a recommended course of action moving forward to take care of your problem. You did the same with the attorney, and you're relying on their expertise. And I think if you tell the client, there's those people that go online and find out, put in their symptoms and try to be self-doctoring, and really doesn't work as going to a real doctor. It's very similar in law. I think that analogy may work, right?
And what you're talking about, John, is really important. I mean, part of the skill, and most importantly, the judgment that we as professionals exercise on a daily basis is: do we have enough information to exercise our judgment, to give an opinion, in the medical field, to make a diagnosis? The What happens when you use tools like AI or consult somebody who may not be an expert in his field is you're supplying the information, and you've self-designated what's important to know. You're not the expert in collecting the information that's necessary to make a diagnosis, but you've decided that you are when you put it into an AI engine as a non-professional. And I think that's that's an important distinction to make when we're talking to clients about the usefulness of this technology. The clients might, in their mind, think, well, I don't need a lawyer because I can just go to this. The lawyer who is using these tools can use them in such a way to really be more effective and to be more efficient with what they're doing. It's not replacing what they're doing, it's augmenting what they're doing.
Great point. All right,
Back on track?
back on track. Let's keep going.
Okay. Some data security and privacy issues. Obviously, you know, how your data, is encrypted when it's moving from one place to another, end-to-end encryption, what's happening to it at place and when it's in place, what data is being retained, data is being deleted, access controls, permissions, comprehensive audit logging. If we have to pick a favorite here, one of my particular favorites, sure everybody has their favorite data security and privacy issue. Regular security assessments. These are some of the things that you need to consider. There are so many issues that surround data security and privacy that I think the bigger question to address is who at your firm or who are you going to consult and rely upon outside your firm who is going to assess tools for their data security and their privacy. Who's going to review the tools master service agreement and the other relevant documents that really define these concepts. Who's going to really understand them and be able to ask questions, and ultimately who's going to be able to explain internally um, how the tool complies with the security posture that you have decided your firm's going to take. We all, and this is a larger point, we all make decisions about how much risk we're willing to accept, how secure we are going to demand ourselves to be. There are value judgments that you make along the lines. No matter how secure you think your systems are, there is always another level of security that you could go to. But it's always a cost-benefit analysis. Likewise, in terms of privacy, we are almost all of us are under some form of legislated privacy protection in addition to our ethical privacy requirements, and understanding the level to which you are going to protect the private information is something that you have to focus on and understand the interaction between your particular stance, where you want to be, versus where the tools are, and whether they're meeting um, the degree of privacy that you demand. Because once again, as careful as you think you are, and as private as much emphasis you may believe you take on privacy, there's always another step higher. With respect to guidelines, I personally believe that in addition to explaining what the AI tool is there to do, explaining the what tools are approved, what tools are used for what tools are basically firm tools, what of the commercial or publicly available tools can be used, and how those should be used, that you also have to always remind people to read, verify, and edit. And this is a feature of our internal policy that it can be somewhat unique, I think, to some of the others, because we're really at every step of the approach emphasizing the importance on to folks that they need to focus on the output and make sure that the output is accurate and complete, and then edit the output in the appropriate way. Um, you know, Talking about guidelines for use of freely available tools. This presupposes the question of whether you're going to allow your folks to use freely available tools. What are those? Those are the Chat GPTs, the Claudes, the Copilot's a little less commercial or freely available. It's generally found as a plugin that you would provide um, through the Firm 365 subscription. But if you're going to let folks use these tools that they can just grab off the internet, you need to explain to them exactly what's appropriate and not what's not appropriate. Easy. If I'm writing an email to the firm to celebrate the 40th anniversary, work anniversary of someone, I feel pretty comfortable using, Copilot or GPT to help me. There's nothing private there. I'm not trying to keep it a secret. Um, However, if I'm taking a bunch of confidential client information and putting together a letter, an update letter to an expert or a co-counsel, I'm certainly not going to want anybody to dump something like that in a freely available tool. So you need to decide whether you're going to allow folks to use these tools and how you're going to allow them to use it. Um, and I would importantly state what they cannot share with these tools, and identify examples of the things that you're forbidding them to use. Don't put client information into ChatGPT. Okay, that's fine. What is client information? Start to give them examples. Examples are really helpful. The main criticism of examples is that they can be limiting, and when folks don't see something written there precisely, they start to think that is permitted. That's where your culture really needs um, to to be such that if folks have a question, they feel comfortable asking about what's permitted and what's not permitted. Um, Once again, anything that they get from a freely available tool needs to undergo the same degree of verification and confirmation before it's used for anything. Well, I'll just say that, for anything. Now we're moving over to enterprise tools. This would be something like Anytime AI, if your firm were to adopt Anytime AI. Um, what's the advantage of a enterprise tool versus something that's freely available? The firm has taken steps to vet that tool specifically for various use cases within the firm. The firm's taken steps to investigate and is satisfied about the security and the privacy stance of the tool. And the firm's really looked at the fact that the tool is producing information and producing work product, that it feels comfortable with using at different levels. Um, and it's very important to distinguish the enterprise tools from the free tools, because if you don't distinguish that, um, you will be encouraging people implicitly to use freely available tools, perhaps in a way that's less than safe and secure. With any type of enterprise tool, you need to specifically outline what tasks the tool is appropriate for. Um, that this approved use case, sometimes use case, never use case framework um, is extraordinarily frustrating to people with an engineering background. They don't understand what this sometimes use cases is. This is the AI equivalent in policy as the "it depends" answer for lawyers. Um, there, I'm a big proponent of this. I think the sometimes use cases are become the approved use cases very quickly, and to some degree, you want to encourage your people, especially if you create an implementation group when you roll out tools, of people that you really trust, who are very considerate and thoughtful about their use of tools, to develop tasks that and to develop cases where these tools can be used that they weren't originally designed for. It's really also important to list a number of use cases that are just forbidden tasks that people should not be using these tools for.
And what I'll say is that all three of those are probably going to change over time. especially with the speed at which AI is changing and evolving.
Yeah,
And so some of those sometimes use cases will go into approved use cases just because AI evolves and turns it into some and things that were not on the list are going to have to get added to the list because AI has now come out with a way to do something that it wasn't doing 2 weeks ago. It's
absolutely
literally
right.
happening that quick.
Absolutely, John. Absolutely right. And some never use cases will move out of that category. Th this is something I usually say at the very end of this presentation, but it bears mentioning now. When you're putting together any type of policy for anything, but in particular for something that is rapidly as evolving as generative AI, it needs to be a truly living document. It needs to be subject to revision. It needs to be open for revision, as things change, as you're adding tools, as tools are evolving, so that the document is not just fresh in terms of current information, but really addresses the things that your folks are dealing with on a regular basis. Um, a good policy should make it clear how to request approval for tools. Your people will be exposed to things, and they should feel empowered to come to you to show you new things that they've been exposed to. Um, guidelines for approving tools. You could do a whole series of seminars on how to the process by which approving a tool. I will say that I think it's important to put in a use policy so that people who have concerns, and there will be a great segment of your policy of your population that has concerns about using these tools at all, feel comfortable that the management of the firm, that the lawyers at the firm thoughtfully put effort into this at looking at what is an appropriate tool or not. I see that in my slide here, I have the Information Security Management Committee. Um, that sounds like a governmental organization. Um, uh, I was assure you that most firms don't need an information security management committee. You may be the information security management committee, but that's at a large firm, that's a group of people from different practice areas. In a smaller firm, it's someone that's taking responsibility to looking from that lens, from that perspective at the tool. Training. Um, implementation and training are extraordinarily important. You can buy the best tool, you can incorporate the best tool, you can plan and create policies and guidelines to make sure that tool is used safely and appropriately. But if you don't um, roll the tool out in a manner that is positive and meets your users where they are and train them and continue to train them on the tool, it's just not going to be used. And utilization at the end of the day is the most important measure by which all of these tools should be evaluated. And that's on you. You know, no anytime AI can't make your people use it responsibly, anytime AI can't force your users to use a particular feature, um, any company, any vendor can't force implementation. And implementation should never be forced. It should be a journey that you go through with your users so that they understand the change, they understand why it's being done, they understand that there's going to be a rocky road, there's going to be less efficiency before there's more efficiency, and then you get to clear and regular training so that folks learn new things, but also reinforce the important ethical and accuracy related and completeness related aspects of whatever tool you're using.
And I've been in software and legal software for quite a long time. I think it's important, regardless of whether it's AI software or any others, to make sure you have a vendor who is going to support your training needs and really find out what they are as a part of your evaluation process of which vendor to go with. Is how are they going to support your way that you need your people to be trained and onboarded in this tool being implemented? So,
Excellent point, John. Excellent. Uh, so what happens when something goes wrong? And things sometimes go wrong. Uh, let's outside the AI world. Draft copies of briefs have been uploaded to Pacer. Um, Folks have accidentally electronically filed confidential information many times over recent history. AI just gives us another opportunity to do the human things that human mistakes that we make, and it's always through a failure to verify. Because just like you would never take a summer clerk or first year um, uh, lawyer's draft and without reading it submit it to the court, you should not be doing the same thing with any type of work product that's coming out of any type of generative AI tool. But it will happen, and you need to create that balance of when folks realize that something happened, to make sure that that's brought to your attention as quickly and as clearly as possible. Look, bad news never gets better, um, and people need to feel like they can share the bad news that they know with the people above them in the management chain, and you need to create an environment where that's possible. I am talking now about negligent mistakes. I think we've all seen the negligent mistakes of lawyers filing briefs with case law that is non-existent. Um, sure, the AI put out bad information, but somebody failed to check it. And at the end of the day, our failure to check something is not explainable, because we always have that obligation to do that regardless of where the output came from. Um, we're now seeing judges, unfortunately, having the same issues with, there have been a few opinions in different parts of the country that have included non-existent case law, non-existent quotes. Whether that information came from a brief submitted by one of the parties, or whether that information came from a law clerk who was using AI that hallucinated. Once again, it's a matter of the information not being checked and verified. Um, I assume at some point in time, a totally hallucinated case will probably make its way into one of our reported databases. I just, if you think of the first two waves of errors that have occurred, first at the lawyer level and at the judge level, it's probably going to go beyond that. But at the end of the day, it's all our obligations to check and verify. You need to set that apart from what I would call intentional violations. And intentional violations are the things that you need to clearly identify what the consequences to that are. AI is not the solution to somebody who's put off doing a project that they were assigned 3 weeks before the due date to complete it the night before. When somebody puts themselves in that position and bad data comes out and they didn't have the time to check it, they've engaged in a pattern of activity that needs to be addressed. So um, understanding what is driving breaches and violations is very important, and setting forth a clear mechanism by which the information of a problem, an issue that's arisen, so that can get to the place where it can be addressed. Um, you know, lastly, with your AI policy and with your AI tool, it's very important to make sure that everybody knows it. shout it from the rooftops, pump it out in email, have meeting or meetings about it. Talk about it, make it part of your lexicon when you talk about the tool, talk about the policy, and keep coming back to it, so that it is refreshed, it is current, and it is something that is relevant for what you're doing at the firm at any particular time. Um, One last thing that I touched upon earlier a little bit about implementation of the tool in the materials that were part of this program. There is a mock implementation schedule. The focus of this program was not implementation of itself, but I believe implementation is so much a part of policy that having an idea of how you're going to roll the product out, together with the policy to assure that it's utilized is a vital part to being successful. And I hope everybody takes a look at that. Um, Thank you very much. That's the prepared part of this program. I hope that you all got something out of me talking into a camera for the last 50 minutes or so, and I'd be happy to answer any questions.
Yeah, I appreciate you taking all the time to come on. We will be sharing all of the slides out with folks in a follow-up email, as well as the CLE information that you need. Um, and um, and if you do have any, well, it looks like one question's coming in. Just says thank you, awesome topic, and very relative time with all the advances in AI unfolding. So yeah, appreciate that. It is wild to me that so many firms are hopping on and using ChatGPT and some of these other tools for things that they shouldn't be. Um, and really appreciate you taking the time to kind of lay out what should be in a policy and how your firm looks at it. I think it's important um, to the industry as a whole. So much appreciated.
Thank you, John. And just one more thing. If anyone has any questions, specific questions about this topic or anything to do with implementing anytime AI or generative AI in general in your firm, be happy to hop on the phone, hop on a Zoom, engage in an email conversation, chat on Teams, all the different ways that we communicate these days. I even get together with people at lunch. But this is something that I'm very engaged in, I'm very interested in, and I have lots of examples if anyone wants to benefit from the things that we've collected. Um, and there's a lot of questions that I can't answer. We've got some wonderful people here that that certainly will be happy to help anyone who reaches out to us. Thank you, John, for giving me and our firm the opportunity to work with Anytime AI and to participate today.
Well, thank you very much. And you'll see Michael's contact information is on one of the slides that's here. And very gracious of you to allow folks to reach out to you. So thank you very much. I do appreciate everybody's time today. This is something that we will be doing once a month, is offering these types of CLE presentations. If anybody has any suggestions on CLEs, we are open to all suggestions. We really are trying to get useful information for all the plaintiff firms to really help better the whole community and your practice. So we're going to try to continue to do these and bring these types of programs to you in the future. So again, I just want to say thank you to Michael and to Stark and Stark for number one, hopping on, number two, being such a fantastic customer of ours and a great partner. And thank you for everybody that came on. And I hope you all have a great rest of your day and a great weekend. Thanks.
Have a great day. Have a great weekend.
All right, take care.